The Honourable Mr Sims.
Thank you, Mr Acting President. I rise to speak on this bill on behalf of the Greens. In so doing, I want to make it very clear that peace and non-violence is one of the four pillars of the Greens political party, and indeed we condemn all forms of violence. Violent crime, knife crime, really should have no place in our society and our state, and I recognise the significant distress that these crimes do to members of our community, and of course the need to manage that behaviour and ensure that there is appropriate criminal sanction. Indeed, it's my view that the law does already have significant penalties in place, however, for this kind of offending. And I do worry that some of the legislative approaches we are seeing from the Malinauskas government of late are moving us back into the populist law and order years that we saw during the RAN era, where what the government seems to be focusing on in the law and order space is populist politics, winning news headlines, but not actually tackling the root causes of crime. If the government is genuinely concerned about young people participating in criminal activity, and in particular knife crime, then when will it come to the Parliament with a clear strategy to deal with the fundamental causes of crime? Why does it instead keep focusing on penalties when we know from all of the evidence over the years that harsher penalties just simply don't work in terms of dealing with the causes of crime and making our societies safer? These sorts of laws are really good for getting newspaper headlines, but they don't necessarily do anything to make our streets safer, and they certainly don't do anything to address the social factors that might be leading young people in particular down a pathway of criminality. So, I just urge the government to do better when it comes to policy in this space. The Honourable Frank Pangello has addressed the submission from the Law Society. I don't intend to go through all of that again, but there are a few elements that I think are worth highlighting from the perspective of the Greens' contribution. I note in the Law Society's letter to the Honourable Kayam Ma, the attorney, dated the 17th of February, their submission to this bill. They note or question the pace at which these reforms are being progressed, and suggest that a more fulsome consideration of their impact could be conducted, such as referring the bill to a select committee of the Legislative Council to consider the bill and related issues. And I do wonder why the government hasn't sent this through to the Legislative Review Committee, so that there would be an opportunity to consider how this bill might interact with other criminal law that we have in our state. It does worry me that once again this chamber is being asked to legislate without being cognisant of the potential implications. One of the issues that the Law Society talks about here is the broad definition of a knife. The fact that a knife includes a blade, for example, this could be a razor blade. The Society notes the importance, this is a quote from their submission, that is to be placed on the practical interpretation of supply for the purposes of both proposed offences, and whether that extends to merely making the knife available to a minor, such as by not locking it away. The definition of knife for the relevant part of the Act is broad, and this includes a blade, for example, a knife blade or a razor blade. The possible application of proposed section 21D 2B, despite its less significant penalty, is concerning for the Law Society. Notwithstanding the important policy considerations to prevent minors being supplied with knives, the offence provision should be carefully considered, noting in particular the broad definition of knife and the range of circumstances in which the offence provision in existing section 21E could be enlivened. The Society briefly notes the significance of the 4-year penalty, which is considerate for the Act, noting that only 3 other provisions have commensurate penalties, being in relation to weapons prohibition orders, as well as the distribution of invasive images and indecent filming. It is also notable that these offences are committed by the principal offender rather than a third party. Members of the Law Society's Children and the Law Committee noted that the reference that the person knew or reasonably ought to have known, as per paragraph 7 above, to enliven the offence. The Society queries whether the mental element that attaches to the offences, particularly proposed section 21D2B, should be simply knowledge, and that if a person supplies a knife knowingly, it will be used in the commission of an offence. This is particularly so given the fact that the definition of supply, as per above, remains uncertain, noting the offence may be enlivened in a range of circumstances where a minor might merely have access to a knife. Now, this broad definition is concerning to me, Mr. Acting President, and is there the potential to capture a range of conduct that the government may not necessarily have within its contemplation? And I do intend to ask a few questions about that in committee stage. The point that the Honourable Frank Pangello touched on that the Law Society raised, I also think is a fair one, and that is about the potential implications of a bill like this to young people working in regional areas or being in regional areas that might be going on a fishing trip, for instance, and have a fishing knife on their person. Again, there's lots of scenarios that I am concerned have not been appropriately considered. Indeed, as noted by the Law Society in their submission, and I quote, "There may be numerous personal reasons why young people may not have adults that can purchase knives for them. The Society's Children and the Law Committee understands there is a significant number of young people that live independently by the age of 16 years, and not all youth can rely on an adult to purchase a knife, which in many cases may be necessary for living independently or partaking in a range of activities. A further reluctance might stem from public awareness as to the reforms described, which may render an adult less likely to provide knives for young people, even if young people are likely to use them for a legitimate purpose, especially if that person is not their responsible guardian. While well-intentioned, the reforms take a position which does not give due consideration to the fact that the vast majority of young people between the ages of 16 and 18 are trying to enter the adult world and are not intending to commit crimes." And indeed, this is the worry I have with laws like this, in that what they tend to do is stigmatise young people, in particular vulnerable young people in our community. And when we're talking about giving police new powers to target particular groups, we know the young people that will be targeted. We know, based on what has happened in law enforcement in our state over many years, it's going to be First Nations children that get targeted by these sorts of laws disproportionately, or other young people that are deemed to look suspicious. And that really worries me. These sorts of laws, I think, tie into a stigmatisation of young people in our society, can actually alienate young people and lead them to be more likely to commit offences in the long term. I note that there's been some debate about similar, not exactly the same, but similar laws over in Queensland. And the Queensland Council of Civil Liberties has expressed some concerns regarding the way in which those laws operate. And I think it's worth highlighting some of those concerns, Mr. Acting President, because I think they do apply similarly to the legislation that we're debating here in this Parliament. The Queensland Council of Civil Liberties said of similar legislation there that these laws abrogate a fundamental protection of individual liberty by removing the requirement for police officers to have a reasonable suspicion prior to conducting a search of a person. And they note their concern that the power could be abused by police officers who will search people based on prejudices and generalisations about people in the community. They also express concern that pressure will come to expand these powers, and this has already happened. Originally, the measure was to be used only in safe night precincts. It's been extended to public transport. It's being extended to shopping centres and recreations. and they note that there will be pressure to extend the laws to other areas. The Queensland Council of Civil Liberties also notes there was a review of the initial trial of these powers by Griffith University, and no evidence was found in that study that the searches enabled by the legislation had actually reduced offences. And in particular, the Griffith University review found that during the trial of Wanding, many people who were searched due to police racial bias. I noted in particular that Indigenous people were searched disproportionately. So this worries me, Mr. Acting President, when we're making law that has such wide-ranging consequences, and these elements are not being given appropriate consideration by government. I note that a number of members have filed amendments. I will listen to the debate in terms of forming a position on those. I think it's worth noting, and the Honourable Frank Pangello touched on this point, I would just encourage members, particularly of the two large parties in this place. I understand they have their party rooms on a Tuesday morning or a Monday afternoon, and that amendments may be filed soon after that. But it would be very helpful for the crossbench to get advance notice of amendments, particularly when they relate to this level of complexity, because I only saw the amendments early this afternoon. It does make it difficult to be able to engage with stakeholders and form a view. I note the Honourable Connie Benares has filed amendments to expand this principle somewhat, and I am concerned about how that might work in a retail setting, for instance, and so I'm certainly not supportive of that amendment, but I'll hear the honourable member's explanation of the amendment, obviously when we get to the committee stage. As I indicated, I will have a few questions to ask of the government in the hope that they may allay some of my concerns. But from my perspective, this seems to be more about a race to the bottom between Labor and the Liberals when it comes to law and order, rather than actually addressing the root causes of crime in our society. And I'd really like to see the Malinauskas government start to do some work in that area, rather than continuing to engage with this race to the bottom with the Liberals on law and order.